stop. I'll fix you up, make everything much smoother again. I'll fix you up, from sunrise till dawn, my friend. I'll fix you up, with these hands and heart so true. I'll fix you up, Daniel, I'll fix you up. The connections might be tangled, the power source has lost its spark, but every wire tells a story, and I can mend what's torn apart. From sunrise till dawn, I'll be here waiting. From sunrise till dawn, I'll never stop. I'll fix you up, make everything run smooth again. I'll fix you up, from sunrise till dawn, my friend. I'll fix you up, with these hands and hearts so true. I'll fix you up, Daniel, I'll fix you up. When the current isn't flowing, when the signals disappear, I'll be here with tools and patience, make the static crystal clear. Every cable, every circuit, every problem that you bring, I'll restore what time has broken, make the whole world sing. So don't you worry about tomorrow, don't you stress about today. I've got maintenance for your troubles, and I'll chase them all away. I'll fix you up, make everything run smooth again. I'll fix you up, from sunrise till dawn, my friend. I'll fix you up, with these hands and hearts so true. I'll fix you up, Daniel, I'll fix you up. Hey, Daniel, everything's good as new. Hey, Daniel, I'll fix you up for you.
Well, welcome. I think we are here today. Yes, we are doing good today with no technical difficulties. So welcome to the show. I am your gracious host, Daniel. And today is Judge Vonda Bailey, who does the family court stuff, like child support and stuff like that. It's all part of the justice system. It's all part of the courts. So I will be here. We're going to get started pretty soon. I'll be here, but I'll be watching. I'm going to be muted so you can't hear me. So let's get started with Judge Vonda Bailey. Share my screen. Make it bigger. There we go. So here we go.
Okay, we are now live streaming on the course YouTube channel. With those who intend to testify, please raise your right hand. Mr. Rogers, we can't see you. Okay, if you'd hold the phone up. Yes, thank you. All right. Do you all swear or affirm that the testimony you'll give will be the truth and the whole truth?
Yes, ma'am.
All right, thank you. Let me see. We didn't get your answer, ma'am. You're on mute.
Yes, ma'am.
Thank you. All right, so Mr. Rogers, we are here on the request for the de novo hearing filed through your attorney, Mr. Morales. Is that correct?
Yes, Your Honor.
Okay, and just so the court is clear, the issues that are before the court are naming the mother, the sole managing conservator of the child, and father possessory conservator, father having no access to the child until further order of the court, ordering father to pay child support in the amount of $680 beginning April 1st, 2024, as well as ordering father to make a child support payment of $340 no later than March 15, 2024. Is that correct?
Correct, Your Honor. And if I may, if now's the right time, just kind of add, I guess, a little maybe twist to this. Since filing, I've had a chance to meet with my client, and we on Friday we filed a pleading counter petition to pleading challenging the paternity in this case. So it's something that I think is at issue, and we need a determination about. My suggestion would be that we have the DNA test ordered by the court and performed. And once we know the outcome, then we can proceed with the child support and possession.
Okay. Yes, that is a valid point. I'm just curious. When you all went to the Attorney General's, well, there's an acknowledgement of paternity on file.
Correct.
That was before he had counsel, Judge.
I understand, but counsel knows the significance of the acknowledgement of paternity. I
understand. And so that's our burden to overcome. And that's the pleading that we have on file.
State?
Judge, I object due to being a valid acknowledgement of paternity. I'm happy to take testimony if the court allows, but the state does object on its face.
Yeah, counsel, which pleading did you file to challenge the paternity?
Judge, this would have been, I believe, Friday of last week it was filed.
Right. I don't see it yet, but what was the name of it?
Just, I want to be precise, Judge. So it was a petition, counter petition challenge acknowledgement of paternity.
Okay, counsel, what authority do I have to not proceed with the appeal hearing and to order DNA testing?
Sorry, Judge, I'm just reviewing what was filed.
No problem.
I believe it's chapter 160 of the Texas Family Code. It allows for the request. The child was born last August, certainly within the time period.
Yeah, I just read about this. Keep going, I'm listening.
Sure, and what's pled is in the allegations is either material mistake of fact, fraud, or duress. I think this most likely would be under material mistake of fact.
Okay, so filing a denial of paternity. A presumed father's paternity can be rebutted if the presumed father files a valid denial of paternity and another files a valid AOP. I don't think that one would be applicable here. it says, reading on down, father by acknowledged paternity. A man becomes a father if he effectively acknowledges his paternity. An acknowledged father is a man who has executed an AOP under Family Code 160.302. A valid AOP filed with the Texas Vital Statistics section, which is what I'm looking at, is the equivalent of an adjudication of paternity. It confers on the acknowledged father all the rights and duties of a parent under the Texas Family Code. Rescinding an AOP can be rescinded by the child's mother or the man acknowledged. If the acknowledgement became effective on or after September 1st, 2011, a signatory can rescind it by simply filing a completed rescission form from the Texas Vital Statistics. Has he done that?
Rescission form has not been filed, Judge. What we filed was just the pleading challenging the acknowledgement of paternity. But we would certainly be within our right to amend the pleading to add that form.
Mm. So if I'm reading this correct, for purposes of the signing of the AOP, dad would be the acknowledged father.
Correct.
Right. And I know the state has an objection, but I mean, I'm not seeing anything unless I'm overlooking it. Does the state have any authority that says that the court cannot entertain a DNA test? The only issue is the actual pleading is not before me today. Um,
Judge, if I may, I think the applicable section, that's what was pled. But I referenced section 160, but specifically 160.308, which is a challenge after expiration of period for rescission. And that's under the basis of fraud, duress, or material mistake of fact. And it lays out that it is our burden, and it also allows for the DNA or genetic testing.
160 point, give it to me again.
I'm sorry, 160.308.
Thank you. Let's see. After the period for rescission under section 160.307 has expired, a signatory of an acknowledgement of paternity or denial of paternity may commence a proceeding to challenge the acknowledgement or denial only on the basis of fraud, duress, or material mistake of fact. Well, this also says the proceeding may be commenced at any time before the issuance of an order affecting the child identified in the acknowledgement or denial, including any order relating to child support. That's already happened.
Correct.
So I think you're late. This would have, the challenge, according to the code, section A, the challenge would have had to been made before any orders were rendered before the court or by the court. So that's the issue.
That is the issue, Judge. And, you know, I guess my position is Mr. Rogers did not have counsel at the previous hearing, which was, you know, part of why we are where we are now. And
Right. You're
you know,
talking about in front of the child support judge, right? Or you
this would have been
Judge Lee?
correct. This would have been in front of Judge Lee. And I don't believe anything happened in the child support court other than an acknowledgement that we have this case currently pending in front of you.
Yes. So in reading, in review of the docket and in conjunction with the code, what the law says, this would have had to have been done before the hearing took place on March 24th, March 5th of 2024.
And Judge, if I may be allowed to brief this issue, because it is a significant issue, if it turns out that, you know, he's not the paternal father, this would be his one opportunity to challenge that. You know, if it turns out that he is, then I think we would have no problem proceeding.
Okay.
But I think it's a pretty significant issue, if I may.
I mean, it is a significant issue. I don't disagree with you there. If you would brief, I would need something that says that the court is allowed to order DNA testing after an order has already been issued by the court.
Okay, I understand.
Yes, so what we'll do is I will, how long do you need for a brief?
10 days.
10 days. Okay, so we will suspend, if everyone would get their calendars out. The next available I have is the week of May the 20th.
I'm available on the 20th, Judge.
Okay.
I am as well, Your Honor.
All right, State?
The state's available on the 20th as long as it's Zoom, Your Honor.
Yes.
Just for the 20th. Okay.
Yes, at the same time, 1 o'clock. Does that work for everyone?
Yes,
does,
I'll
Judge.
be available.
Oh, I didn't hear you. I'm sorry.
Yes,
Yes,
ma'am,
Judge.
I'll be available.
Okay. All right. Okay. Got all these books here. Okay. So I have you all reset for Monday, May the 20th, 2024 at 1:00 p.m. on the same Zoom, 688-044-0164.
Can you repeat that?
Received.
for me?
Sure. All right, it's 688-044-0164.
Okay.
All right, and if there's nothing further, I have you all reset. You are dismissed.
Thank you, Judge.
Thank you,
Appreciate your
Judge.
time.
Thank you.
Y'all take care.
Thank you.
Take care, Judge.
All right. I'm going to I'm about to admit the next case. All right. Good afternoon.
Good afternoon, Your Honor. How are you today?
Good, good. How are you?
Good.
All right. Looks like we're waiting on the other side.
That could be. I'm not sure.
Yeah, you represent the mother?
That's correct.
Okay. I want to confirm I have your exhibits. Looks like it's 1 through 26.
Correct, Your Honor. And I realize we're on a short time period and we don't plan to use all of them. It was kind of an abundance of caution thing.
Okay.
Is it correct that we'll be limited to 10 minutes per side?
What is this? De novo appeal, 15 minutes.
15. Okay.
Yes.
Okay. Well, we'll just be on standby here until you are ready to proceed.
Well, I am when the other side come. I don't see anybody logged in just yet. Let me see. And the other side is the moving, correct?
Well, both sides filed de novo appeals.
Okay.
The original hearing was our hearing. I think they may have filed their de novo slightly before us, but they were filed the same day, I believe.
Okay. Counsel, will you mind calling the other side? Just to make sure, they have the right Zoom code, everything like that. I don't want to delay anything.
Sure, Your Honor. I will put you on mute and call their office.
Okay, thank you so much.
It said,
Hi there.
Hello.
Let me see. K, is it Karanko? Karanko?
hi, Judge. It's Karanko. I'm sorry. It looks like we had the wrong Zoom code. I'm letting Marilee, our client, know now.
Oh, okay, no problem. Okay, looks like the only person we're missing is Attorney Lewis. You got it. Okay. And I just wanted to confirm that I do have respondents, well, moving respondent, because I know you all filed competing appeals. I do have those. Looks like it's P1 through 9.
That looks correct to me as far as what was served on us, Your Honor.
Okay, thank you. Okay. Good afternoon.
Yeah. Good afternoon, Judge. I'm sorry, I was on the other Zoom site. I don't know why I had a different Zoom site, but anyway, I apologize for my tardiness.
No worries, no worries. I knew something was wrong. I said, you're never late.
Oh, you give me entirely too much credit. Thank you.
All right, so both sides ready to proceed?
Yes,
Yes,
Judge.
Your Honor.
Okay, before we go on the record, I wanted to get you all to stipulate to the exhibits as most, as much as you can. I'm assuming there will not be any of, let's go through, whose is these? Hold on one second. Let's go through, father's exhibits first. Looks like P1, is there any objection to the summary of requested relief?
No objection to that, Your Honor.
All right. P1 is admitted. P2?
No objection to that either.
P2 is admitted. P3,
No objection to 3.
all right. P3 is admitted. P4,
No objection to 4.
right. P5,
No objection.
okay. 6,
No objection.
right. 7,
I have a relevance objection to that. I'm not really sure what it's used for.
okay. Well, you can raise the objection if they present it during testimony. So I just reserved that one. P8,
No objection
all right. 9,
and no objection.
okay. All right, now let's go through respondents' exhibits. Any objection?
And,
Oh.
Judge, I won't be using all of them. I can just tell you which ones I will be. P1, or sorry, M1, obviously.
Okay, M1,
No objection.
all right. 2,
M2,
any objection?
No objection.
Okay. 3,
M3,
I do object to that one, Judge.
okay. 4,
we are going to use that one.
okay. Any objection to 4?
If it's being withdrawn, Judge, I have no objection to it being withdrawn.
Oh, we're not withdrawing that, Ms. Lewis. We're still using that one.
Oh, I'm
Okay.
sorry. I thought you said P4 you would not be using. I misunderstood. I'm sorry.
So there's an objection to 4. What about 5?
Judge, it's a certified copy. No objection.
All right. 6,
6, 6 and
I think
7,
that
Judge.
one is service.
I have no objection to 6 or 7.
Okay.
Pleading's already before the court.
8,
8 is a wage statement. It's listed as income and expenses, but I think I have no objection to it as a wage statement.
okay. It looks, from what I can see, it looks like a wage statement. And then it looks like a financial report as you scroll down to the second page and second and third page.
Right, it covers income and expenses, Your Honor.
Okay,
No objection, Judge. Well, we would of course like to see the supporting documents, Judge.
okay, but no objection as a summary?
No objection as a summary, just noting that the supporting documents are not attached, with the
Okay.
exception of the wage statement.
Okay,
And
9,
Your Honor, 9 through 12, we won't be using today.
okay, so 13,
13. No objection.
14,
We won't be using that, Judge. The next one we'll be using is 17.
okay, 17,
That's a business records affidavit that's been duly filed with the court. No objection.
okay, so 17, okay, 18. Looks like what is that, criminal record?
Certified copies.
Certified, yeah.
I cannot object to them.
18,
We won't, I'm sorry, 18, there was no objection. Was that right?
That's
Yeah.
correct. That's a certified
Okay.
copy.
19, we won't be using, but we will be using 20.
okay, any objection to 20?
To the extent that, and I would have to ask Mr. Rewalk if these have been previously provided to council.
This is 20, Ms. Lewis?
Yes, 20.
Okay, yes, they were entered at the temporary hearing.
If they've been previously used, then no objection to 20.
Okay, 21,
And Judge, the only other one on the list we'll be using is 22.
okay. Any objection to 22? Looks like it's
It's a protected.
certified.
It is.
Okay. All right. So now we're going to record. Yes. All right. We're on the record in cause number DF 2314885. Councils, will you please announce for the record?
Scott Rewalk for movants and mother Amanda Brown.
Thank you.
Marilee Lewis for petitioner in the underlying divorce cause and also movement for purposes of de novo review, Joshua Ryan Brown.
All right. With those who intend to testify, please raise your right hand. Oh, and take yourself off of mute. All right. Do you swear or affirm that the testimony you'll give will be the truth and the whole truth?
I do, Your Honor.
Thank you. I just want to make sure that everyone is aware that the court is streaming live from the court's YouTube channel, as well as the courtroom doors are open in terms of being in compliance with the Texas Open Courts Act. I do realize that there are some issues that are involving domestic violence. So I would just advise you to just be cautious with certain words that you may use, because YouTube will take the video down immediately and it'll stop live streaming. I don't want anyone to think that I'm trying to hide anything. I just wanted to make sure you all are aware of that.
And Judge, I'm sorry.
Go
We
ahead.
We would respectfully request that we not live stream. There is a minor child. And for the best interest and protection of the child, we would ask that we not live stream.
Yeah, I understand, counsel. However, all of our live streams, pretty much majority, all of them include children.
So noted, Judge. Thank you.
You're welcome. Okay, so councils were able to stipulate 2 exhibits, and thank you all for doing that. So petitioners exhibits 1, 2, 3, 4, 5, 6, 8, and 9 are admitted. Respondents 1, 2, 5, 6, 7, 8 as a summary, just noted there are no supporting documents to 8. 17, 18, 20, and 22. Council, does that sound right?
Yes, Judge.
Okay, thank you. All right, so it looks like we have competing appeals. It looks like Attorney Lewis, your client's appeal came through first. I mean, it really doesn't matter. Y'all are competing. So essentially you all are challenging the associate judge's ruling that was done back on February 27th of 2024. Is that correct?
Yes, Judge, that is correct.
Okay, and if my notes are right, there is not an agreement on, in terms of mother side. Let me just make sure I have this right. Okay, and Attorney Lewis, you filed an amended request for hearing, is that correct?
See, Judge, I don't believe we amended ours, but I'll double check.
Okay, I see amended here. And then you while you're looking at that.
Yes, Judge, I do see it now. We only had to amend because we had a typographical situation, not a difference in our requested relief.
Okay, all right. So if the court is looking at this correctly, you all are you're doing a de novo on the entire ruling.
We are limiting, we had requested de novo on the entire ruling, but for purposes of today's proceeding, noting the time limitations, we will be focusing primarily on 2 issues. One, the judge's denial of our request to have this child returned to Dallas County, and 2, financial issues relating to exercise of parenting time.
Okay. All right. Parenting time. Okay. You said denial of the child being returned back to Dallas, correct?
Yes, Judge.
Okay, thank you for that. And let me pull up the other appeal. So it looks like Mrs. Brown is appealing the court's ruling to reserve temporary spousal support in the amount of $1,500, the interim attorney's fees in the amount of $5,000, as well as the Father's Day weekend that's coming up, correct?
So that last item, Your Honor, that's just that there was a weekend carve out for Father's Day for the father. And we just wanted to make sure that the mother had a carve out for Mother's Day.
And Judge Jess's background, we aren't on a first, third, and fifth schedule, which I think is why Mr. Rewack wants to be sure that we have a carve out because of the parenting time. Because Mr. Brown certainly doesn't want to miss any time with his son. So if that carve out means that he goes 3 weeks without seeing his son, then certainly we don't want to have that happen.
Got it. Okay. But those other two issues are still what your client is wanting to appeal today, correct?
Correct, Your Honor.
All right. All right. So I have you all set. And if you're wondering, I'm looking down a lot. I have my real time here. I don't know if you all can see it. I have the real time. So as my court reporter is writing, I'll be able to see what everyone is saying. And if we have to play something back or anything like that, that's what I'm looking at. Just kind of helps with the flow of the hearing. So I have you all set at 15 minutes per side, and that will include any opening and closing statements should you choose to make one, as well as any examination. It doesn't matter who goes first, really. You're both appealing. Is there a preference?
We would prefer to go first if Your Honor would indulge us.
Okay, no problem. Would you like to make an opening statement?
Very briefly, Your Honor, yes.
Go ahead.
Your Honor, this case is a divorce. It was filed in October of last year. The impetus for filing was that what the evidence will show is that family violence occurred for what amounted to the third time in October of 2023. Mr. Brown, the evidence will show, attacked Miss Brown. He was subsequently arrested. A protective order was put in place. We have an active criminal prosecution over it. My client, fearing for her safety and needing family support, has moved to El Paso. She was forced to quit her job when she left Dallas and has since acquired a job teaching in El Paso, where she has been with her family since approximately October. And we're by and large asking for the ruling from Judge Lee to stand, but for those three items that we de novoed, and we're ready to proceed.
Thank you, counsel. Attorney Lewis?
Thank you, Judge. I will defer opening until the presentation of my case in chief.
Okay, sounds good. All right, counsel, you may call your first witness.
Thank you, Your Honor. I call Amanda Brown.
All right.
Will you state your name, please?
Amanda Lorena Brown?
And Amanda, are you Gabriel's mother and currently married to Joshua Brown?
Yes, I am.
How old is Gabriel?
He's 17 months old.
Have you created a summary of the relief that you're requesting from the court today?
Yes, I have.
Permission to share screen, Your Honor?
Yes.
And Amanda, do you see what's been shared with the screen as Exhibit M1?
Yes, I do.
And is this a true and accurate summary of the relief you're asking from the court here today?
Yes, it is.
Your Honor, I'd like to enter Mother's 1.
It's already admitted.
Thank you, Your Honor. Amanda, you're asking for the court to confirm the ruling that you're Gabriel's temporary sole managing conservator within El Paso and Dallas counties. Is that right?
Yes.
And you're asking to confirm the finding that Joshua has committed family violence against you and should have supervised possession.
Yes, that is correct.
And you're asking for Judge Lee's ruling to stand other than your request for attorney's fees and monthly spousal support. Is that true?
Yes.
And are you also asking that you be designated to have possession the weekend of Mother's Day?
Yes, that's correct.
Why did you and Joshua separate on October 7th, 2023?
He assaulted me as I was holding Gabriel.
Have you been granted a final protective order against Joshua in Paso County?
Yes, I have.
Permission to share screen, Your Honor?
Yes.
And Amanda, is what is labeled Exhibit M22 a true and accurate certified copy of the protective order that you got against Joshua in February 2024?
Yes, it is.
Thank you. And to confirm, Your Honor, that is already internet evidence, correct?
Yes, that's correct. Yes.
Thank you, Your Honor. Was October 7th the first time that Josh had assaulted you?
No, it's not.
How were you assaulted by Josh on August 19th of 2022?
He forcefully struck me in the face, hit me with a Yeti water bottle, and also choked me and pulled my hair.
Your Honor, may I share screen?
Yes.
And Amanda, is this a true and correct picture of your face after you were struck on August 19th, 2022?
Yes, it is.
And when was Gabriel born?
He was born November 30th, 2022.
So that assault in August was a couple of months prior to Gabriel's birth?
Yes, that's correct.
And how were you assaulted by Joshua shortly after his birth in January 2023?
I asked him about the time he became agitated and struck me in the face while I was bottle feeding Gabriel.
Permission to share screen, Your Honor?
Yes.
And Amanda, do you see what is labeled as M3?
Yes, I do.
And is this a true and accurate picture of your face taken January 6th of 2023?
Yes, it is.
Has this been altered in any way?
No, it has not.
Your Honor, I'd like to enter Mother's 3.
Mother's 3 has already been admitted.
Thank you, Judge. Amanda, back to the October 7th assault. Where were you and Joshua that night, and what were you discussing?
We were in the hallway discussing the moving of furniture in our townhome.
And how were you first attacked that night?
He shoved me to the floor and kicked me.
And where was Gabriel when that was happening?
He was in the other room, asleep.
Thank you. And after that assault began, what did you do next?
He woke up because of the commotion, so I went into the room to soothe him.
And when you were checking on Gabriel, what did Josh yell to you?
He said that I have 10 seconds to calm him down or he will give me 7 BBs.
And what did Joshua do next?
He went to the other room and retrieved a pellet gun magazine.
And where was Gabriel in relation to you when this was happening?
He was in my arms.
Okay. And when Joshua came back into the room, what did he begin to do?
He started to assault me and then started to hit me with the magazine of the BB gun on my back as I was shielding Gabriel.
So you were holding Gabriel when this was happening, correct?
That's correct.
Did you take a picture of the injury that you received on October 7th?
Yes, I did.
Permission to share screen, Your Honor?
Yes.
Amanda, is what's labeled as M4 a true and accurate photo of your back on October 7th, 2023?
Yes, it is.
Has this picture been altered in any way?
No, it has not.
I'd like to enter M4, Your Honor.
It's admitted.
How were you able to call for help that evening?
I used my Apple Watch and I called Irving PD.
How did Joshua react to that?
He saw the face of the watch light up and he ripped it off my wrist and threw it down the stairs.
And what happened after the police arrived?
Moments later, the police banged on the door, opened it up, and arrested Josh.
Permission to share screen, Your Honor?
Yes.
Amanda, do you see what's labeled as M5?
Yes, I do.
And is this a certified copy of a police incident report from October the 7th?
Yes, it is.
And was Josh charged with child endangerment, aggravated assault, and unlawful restraint?
Yes, he was.
Has he now been indicted for misdemeanor assault causing bodily harm to a family member?
Yes.
Permission to share screen, Your Honor?
Yes.
And do you see what it's labeled as M18, I'm sorry?
Yes, I do.
And is this a certified copy of a criminal complaint against Joshua?
Yes, it is.
Was a magistrate's protective order entered based on this assault?
Yes, it was.
Permission to share screen?
Yes.
And Amanda, do you see what is labeled as M6?
Yes, I do.
Is this a true and accurate certified copy of the magistrate's protective order that was granted in your favor after the assault on October the 7th?
Yes, it is.
Did CPS also make findings against Joshua based on this assault?
Yes, they did.
Permission to share screen, Your Honor?
Yes.
And Amanda, do you see what is labeled as M17?
Yes, I do.
And is this a business record affidavit that you filed back on January the 22nd, 2024?
Yes.
And have all the underlying documents been sent to Mr. Brown's attorney?
Yes, correct.
Your Honor, I'd like to enter M17.
M17 is already pre-admitted.
And were findings made against Joshua for neglectful supervision and physical abuse of Gabriel?
Yes.
Why did you leave Dallas after this assault?
I feared for my safety as well as Gabriel's.
When you left the townhome you shared with Joshua, what did you take with you?
Plenty of things just for Gabriel and I.
Okay. Did you also leave many things with you? Did you also leave things in the townhome?
I did, a good amount.
Permission to share screen, Your Honor?
Yes.
Do you see what has been labeled as M20?
Yes, I do.
And is M20 a series of pictures of the state of the townhome when you vacated it?
Yes, that's correct.
So the items shown in the pictures are the items that you left in the townhome for Joshua, is that correct?
Yes, that's correct.
And the picture in front of us right now, is that a gun safe?
Yes, that is.
And the two first pictures, is that ammunition?
Yes, that is.
Your Honor, I'd like to enter M20.
Okay, it's already been previously admitted.
Amanda, are you aware of whether Josh has disposed of the firearms and ammunition since the protective order was granted?
At the moment, I'm not sure what he's done with the gun, so.
At the time of the assault on October 7th, where were you employed?
I was employed with Dallas ISD.
And what happened with that job after the assault?
I had to resign.
Did you get a new teaching job in El Paso since then?
I did.
And how long have you been in that position?
Almost 3 months now.
Permission to share screen?
Yes.
And Amanda, do you see what's labeled as Exhibit 8?
Yes, I do.
Is this a pay stub for your position teaching in El Paso?
Yes.
And following that, is this a summary of your estimated expenses per month?
Yes, that is.
Your Honor, I'd like to enter Mother's 8.
Okay, it's already been previously admitted.
To your knowledge, does Joshua, in addition to his day job, get income from the VA?
Yes, he does.
Have there been issues arranging Joshua's supervised weekend visitation?
No, there have not been.
Joshua has committed family violence against you, is that right?
That's right.
Despite this, have you ever blocked his phone?
No, I have not.
Since this case started, has Joshua ever missed out on any court-ordered visitation that he's been granted by the court?
No, he has not.
Do you believe that all the requests that you're making of the court today are made in Gabriel's best interest?
Yes, they are.
And in addition to that, are you asking the court to confirm that you have possession of Gabriel for the entirety of Mother's Day weekend?
Yes, I am.
Thank you. Pass the witness.
Okay, and counsel, for a time check, you have 3 minutes and 13 seconds left.
Thank you, Your Honor.
You're welcome. Attorney Lewis?
Thank you, Judge. Ms. Brown, you immediately left Dallas County with your child Gabriel after Mr. Brown was arrested, didn't you?
That's correct, ma'am.
And you actually went to San Antonio, did you not?
I had no family near. I did. Yes, ma'am.
Objection, non-responsive.
Sustain.
You went to San Antonio and you didn't let Mr. Brown know where his child was, did you?
That's correct.
And from San Antonio, you went to El Paso, didn't you?
Yes, that's correct, ma'am.
And you didn't let Mr. Brown know where his child was?
No,
in
I didn't.
El Paso. In fact, ma'am, you were doing your very best to hide both yourself and your child, weren't you?
That's correct.
Ma'am, with respect to the court-ordered visitation, Joshua Brown, the father of this child, didn't get to see the child for his first birthday, did he?
That's correct, ma'am.
He didn't get to see the child for Thanksgiving, did he?
That's correct, ma'am.
And it wasn't until we were able to get on Judge Lee's docket that he actually got some visitation for Christmas, correct?
Yes, ma'am. That's correct.
And you insisted that this child has to be flown back and forth from El Paso to Dallas so that Mr. Brown can accomplish his parenting time with Gabriel, correct?
Yes,
And
ma'am.
ma'am, has Gabriel been injured while in Mr. Brown's care?
Not to my knowledge, no, ma'am.
And you found a job in El Paso, correct?
Yes, ma'am.
You are a teacher, correct?
Yes, ma'am.
And you found a job fairly quickly, correct?
Somewhat, yes, ma'am.
Thank you. I'll pass the witness.
Okay, counsel, you have 13 minutes and 21 seconds left. Any redirect of your client?
One brief question, Your Honor.
Go ahead.
Amanda, you were just asked about your what was termed a demand that you and the child fly back and forth between El Paso and Dallas for visitation. Is that right?
That's right.
How long would it take for you to drive to and from Dallas from El Paso?
With an infant, about 11 hours. That's with frequent stops.
Do you think that would be in Gabriel's best interest to be put through regular drives like that?
I don't think it's feasible for him. No, I don't.
Pass the witness.
Okay,
I'm sorry, Judge, no further questions for Ms. Brown.
thank you. Counsel, you may call your next witness.
Thank you. I call Mr. Brown.
Okay, you have 2 minutes and 46 seconds. Go ahead.
Thank you, Your Honor. Mr. Brown, you're currently employed, correct?
I am, yes.
And you are employed at a law firm, is that right?
Yes, I am.
Okay. And what is your hourly rate at the law firm that you work at?
It's right around 23.
Okay. And you have other sources of income, is that correct?
Just the VA disability.
And how often do you receive VA disability?
Monthly.
And how much do you receive monthly for that?
It just got up to 4,100.
And is 4,100 net or gross?
That's net. It's tax free.
So your resources include the 4,100 a month from VA and your income from your job at the law firm. Is that correct?
Yes.
Are there any additional sources of income beyond that?
No.
Okay. And you do not doubt the veracity of any of the documents that have been entered into evidence so far in this hearing, correct?
Objection, improper question, Judge. They're admitted for all purposes.
Sustain.
I'll pass the witness, Your Honor.
Okay, counsel.
I'll withhold my questions until presentation of my case in chief.
Okay, thank you. You may call your next witness. You have 1 minute and 36 seconds left.
I'll reserve the remainder of my time, Your Honor.
Okay,
Judge, are you ready for me?
yes, counsel, thank you, Attorney Lewis. Counsel, are you resting?
Yes, Your Honor.
Okay, go ahead.
Thank you. Judge, just briefly, this is a situation where we have an infant. The situation between the parents certainly was a difficult one at best. But Mr. Brown has proven himself to be a loving, caring father, and he just simply wants to be able to exercise as much time as possible with his child. That was denied to him by Ms. Brown, who, despite the fact that the petition was filed in early 2020 or late 2023, it was filed in October of 2023. Ms. Brown was evading service. She was keeping the child from him and has done her best to make parenting time as difficult as possible. We are simply asking that Mr. Brown be allowed the opportunity to parent this child. And if I may at this time proceed with questioning and witnesses.
Go ahead.
Thank you. I'll call Joshua Brown. Mr.
Good
Brown,
afternoon.
good afternoon. You are currently married to Amanda Lorena Brown, correct?
I am.
And you are the father of this darling child, Gabriel, correct?
I am. Yes.
And Judge, if I may share screen,
Yes, you may.
I'd like to show you, Mr. Brown, what's been marked first as P1, entitled Petitioner Summary of Requested Relief. Have you had an opportunity to review that?
Yes, I am.
And does that accurately reflect what you're asking the court to do today?
Yes, it does.
Mr. Brown, specifically, what are you asking the court to do with respect to having Gabriel in terms of having him closer in Dallas County?
I would like him and Amanda to return to Dallas County.
If that doesn't happen, what would you like the court to do?
I think it's fair that then Amanda would pay half of the cost of the parenting visits, since she is the one who unilaterally moved to San Antonio and then to El Paso.
Objection non-responsive.
Sustain.
What are you asking the court to do with respect to the cost of the parenting visits?
I'm asking for Amanda to pay for half.
And why is that, sir?
We're currently paying for 2 round-trip tickets to pick him up and drop him off.
Joshua is not of an age where he can travel by himself, is he? I'm sorry, Gabriel's not of an age where he can travel by himself, is he?
He is not.
Someone has to pick him up and bring him back and then go with him back to El Paso from there, correct?
That's correct.
I will show you what's been marked and admitted as P2. Is P2 a copy of your pay stub with Wentz and Zaffarelli LLP?
Yes, it is.
And you are not a lawyer currently, are you?
No, I'm not.
But you are working for a law firm, correct?
Yes.
And the court cannot use disability to calculate additional payments for child support, correct?
Jack,
Yes.
seeking a legal conclusion.
Sustain.
I'll show you what's been marked as P3. What type of activities do you and Gabriel indulge in when he comes to visit?
When he gets in, typically goes right to sleep because he gets in so late. But the next day we go try to do some fun activities. We've gone to the children's aquarium. We've gone to the Fort Worth Zoo, and really, I think we have also gone to like a play area for him, kids zone.
And when you are engaging in these activities with Gabriel, you're having to pay the cost for yourself and Gabriel and someone else, a supervisor currently, correct?
That's correct. Yes.
Has Gabriel ever been injured while in your care?
Of course not.
Let me show you what's been marked as P4. And can you tell the court what P4 is?
P4, that's Gabriel and I at the townhome, enjoying our time together.
And if you will, that is Gabriel as he currently looks.
Yes, that is.
And how much time do you actually get to spend with Gabriel?
In total, about 20 hours throughout the weekend, not including his sleep.
When you say Gabriel gets in so late, what do you mean exactly?
Because he has to be picked up after 6, the flight that we're best able to get to accommodate that schedule is after 6 and then doesn't get in until pretty late, typically.
And what time does Gabriel return on Sunday?
He has to be back by 6. He typically will get him back there by 4 just because of the flights. That's all they can accommodate.
So basically, how many hours on your weekend are you getting to spend with Gabriel?
I'll object to relevance, Your Honor. There's no request for relief to change the schedule.
Judge, this goes to the cost involved.
Okay, overrule.
So, Mr. Brown, how many hours a weekend do you get to spend with Gabriel?
All in total, right around 30 to 33, if I had to give my best guess.
Mr.
Hours.
Brown, thank you.
Mhm.
And that's every other weekend, 33 hours approximately, correct?
Correct. And currently, we've only been doing them once a month.
Why is that?
Well, it's because my mother has to travel down. She's been taking care of her mother lately, and the cost burden associated, unfortunately.
But Judge Lee has ordered that your mom can supervise the visitation, correct?
That's correct.
And would you like more time with Gabriel?
Absolutely.
Object to relevance, Your Honor.
Overrule.
So if Ms. Brown were to be ordered to pay half of the cost of the parenting schedule or flights, would that in any way assist with the parenting time?
It would.
She's in El Paso and knows the schedule and could get the child to and from flights, correct?
Object
Yes.
speculation.
And you heard her
Hold on
testimony.
1 second. Let me read that back. She's in El Paso and she knows the schedule and can get the child to and from flights. Sustain, rephrase, counsel.
The flights originate in El Paso, correct?
Yes.
And that's where Ms. Brown took the child after first leaving Dallas to go to San Antonio. She then went to El Paso, correct?
That's correct.
And so naturally, the flights originating in El Paso with Ms. Brown being in El Paso, she would have greater access to the El Paso airport than you would, correct?
Yes, that's correct.
And Mr. Brown, Ms. Brown is currently employed in El Paso.
Yes, she is.
Are you in a position that you can pay spousal maintenance or interim fees at this point?
Not right now.
Did Ms. Brown pay any of the debts associated with you and Mrs. Brown's townhome in Dallas when she left in October?
No, she did not.
Objection, assuming facts not in evidence, Your Honor.
Sustain.
Is there a monthly payment for the townhome?
Yes, there is.
Is there an existing lease on the townhome?
Yes.
Has Ms. Brown contributed anything toward the payment of that lease since she left Dallas?
No, she has not.
Are you now fully responsible for that?
Yes.
Are you receiving some services from the Veterans Association or Veterans Affairs, the VA?
I have been, yes.
And that includes counseling and
Yes.
additional services?
Yes, it does.
And would you be eligible for additional assistance through the VA as part of an ongoing course of treatment through the VA?
Yes.
So your summary of requested relief, which has been marked and admitted as P1, is what you're asking the court to do today, correct?
It is.
Thank you. I'll pass the witness.
Okay. Counsel, Attorney Lewis, you have 3 minutes and 50 seconds. Counsel, you have 1 minute and 36 seconds. Cross?
Yes, thank you, Your Honor. Mr. Brown, is it true that you're currently in a sobriety program through your church?
It's a recovery program, not necessarily for sobriety, but they focus on Christ-centered recovery.
Okay. And you saw the pictures we entered earlier regarding the items that were in the townhome as of October 7th. Do you recall those?
I do.
And in those pictures was ammunition as well as a gun safe, correct?
Yes.
Are you still in possession of the firearms and ammunition?
No, as I stipulated to at the temporary orders hearing.
And what did you do with those items?
I had to sell them off.
Okay. How much did you sell them for?
It was $1,000 for the ammo and $2,000 for the remaining weapons.
And what did you do with that money?
I put it back into all of the debts that I've had to incur.
None of it was provided to Miss Brown.
Well, some of it was via the reimbursements that I had to send back her way.
Pass the witness, Your Honor.
Okay. Anything further for your client?
Mr. Brown, you've paid child support, or you've paid payments to Ms. Brown for the support of Ms. Brown. You've paid, have you not?
Yes, I have.
You've also reimbursed her for the flight cost until we got clarification from Judge Lee.
Yes, and that was about $1,200.
And we're requesting a child custody evaluation as well, are we not?
We are.
Thank you. No further questions of the witness at this time. Judge, I'll pass the witness.
Okay. All right. Counsel, anything further for this witness? You have 24 seconds left.
One last question, Your Honor.
Go
Mr.
ahead.
Brown, you said that you had provided payments for the support of Miss Brown. Do you recall just saying that just now?
Yes.
Okay. Besides the reimbursement for the flight costs, what additional funds did you provide her?
I believe it was $644 for guideline child support.
And when was that paid?
That was paid on the end of March, and she's got another payment coming tomorrow.
And that's the first child support payment that you made in this case, correct?
That's correct.
Pass
Counsel,
witness.
that was your last question too. You just ran out of
Understand.
time. Attorney Lewis, you may call your next witness.
Judge, I have no further witnesses at this time. If I may ask Mr. Brown 2 real quick questions.
Sure, go ahead.
Thank you. Mr. Brown, you have been supporting the community solely, haven't you?
Yes.
Ms. Brown has not made any payments toward any community debt of which you are aware, has she?
No.
And Ms. Brown is qualified to get a teaching position, isn't she?
Yes, and has one.
In fact, sir, she was working in the Metroplex prior to moving to San Antonio, correct?
Yes.
Would you ask that the court deny her requested relief for spousal attorney or spousal maintenance?
Yes, I would.
And we've not heard any testimony about interim fees, have we?
No.
In that case, Judge, I have no further questions for this witness.
Okay.
I will rest at this time.
All right. Just checking my notes. I wanted to clear something up for the record. So the child is currently 17 months old. Is that correct?
Yes, Judge.
All right. And the second assault was the one that occurred January of 23?
That was this, correct. That was the second.
Okay. What was the date of the first one?
That was August.
August 22?
Yes, August 19th, 2022.
Okay. All right. That was my only question. The court is going to take this under advisement and get a ruling sent out to you all soon.
Thank you, Judge. May we be excused.
Thank you very much, Your Honor.
Thank you
Thank
all.
you, Your Honor.
Brittany, excuse me, Joy, you ready? Yes, I'm connected. All right, we're on the record in cause number DF 2501668. Counsel, will you please announce for the record?
Marla O'Bara, attorney for Lacarian Wilson.
All right. And Mrs. Wilson, you are representing yourself in this matter, is that correct?
Yeah.
Okay, will both of you raise your right hands? Do you swear or affirm that the testimony you'll give will be the truth and the whole truth?
Yes, I do.
And Mrs. Wilson, I can't really hear you. Maybe the volume is a little low.
Can you hear me?
a little bit. It could be your headset.
Hello?
That's a little better. Okay. All right. So we are set today on for a divorce with no children. And it looks like the only issue that's before the court is minor property division. Is that correct?
That is correct, Your Honor.
All right. And prior to going on the record, we had stipulated to some pre-admitted exhibits that will be admitted at this time. So petitioners exhibits 1 through 10 are admitted, and respondents exhibits 1, 1A, 1B, 2, 2A, 3, 4, 5, and 6 are admitted. And the court also takes judicial notice of all contents of the court's file. Did I miss anything on you all's exhibits?
Nothing from here, Your Honor.
No.
Okay. All right. So let me put your time on. You all will be given, due to the tailored, very narrow issues that you have, you all will receive 15 minutes aside. That will include any opening and closing statements, should you all choose to make one. And the court also takes judicial notice of all contents of the court's file. At this time, Attorney O'Bara, would you like to make an opening statement?
No, I'll waive opening, Your Honor.
Okay. Mrs. Wilson, would you like to make an opening statement?
No, I waive it.
Okay. All right. Mr. O'Bara, you may proceed with calling your first witness.
I call Carrion Wilson.
All right.
Please state your name for the record.
LaCarrion Keith Wilson.
And are you the petitioner in this case?
Yes.
And are you currently married to the respondent, Ashley Wilson?
Yes.
And when were you and her married?
May 25th, 2023.
Okay. And when were you and her separated?
I moved out January the 7th, 2025.
And have you and her lived apart since that date?
Yes.
And is there any reasonable expectation of reconciliation between you and Mrs. Wilson?
No.
And have you been domiciled in the state of Texas for the last 6 months and a resident of Dallas County for the last 90 days prior to the filing of this suit?
Yes.
So Dallas County is the proper venue for this hearing?
Yes.
Right now, is this marriage insupportable because of the discord or conflict of personalities that destroys the legitimate ends of the marital relationship and prevents any reasonable expectation of reconciliation?
Yes.
Are there any children born or adopted of this marriage?
No.
And to your knowledge, is your wife currently pregnant?
To my knowledge, no.
Okay. Now, the court entered some temporary orders in this case on August 14, 2025, correct?
Correct.
And those orders awarded you possession of a 2015 GMC Sierra, correct?
Correct.
And the court ordered that the respondent pay the vehicle note, correct?
Correct.
And that was because you had already paid her for this vehicle?
Correct.
All right. And the court also ordered the respondent to pay your attorney's fees up to that point. Is that correct?
Correct.
And did you ever receive any notice? Did the court ever change or suspend or stay those orders for payment of the?
Not that I know of.
Okay. And did you ever receive any notice of any de novo hearing being set to change those orders?
No.
All right. To your knowledge, did the court ever rule differently on the truck or the attorney's fees?
No.
Okay. Now, to your knowledge, did the respondent have the respondent paid you any of the compensation for the truck already paid out?
No.
And to your knowledge, has she continued to pay the truck note?
I'm assuming so because they haven't told it, but I also moved since all of this happened, so I don't know if they know my new address or not.
And up to this point, has the respondent paid your attorney's fees?
No.
Did you rely on the court's order to remain in effect?
Yes.
And as a result, what has happened for the failure to comply with these orders?
I'm further in debt, having to pay lawyer fees and stuff like that. I'm having to steady work part-time jobs, do odd jobs and stuff like that to make sure that I pay my attorney fees.
And are you asking the court to confirm these temporary orders in the final decree?
Yes.
Are you also asking the court to grant your petition for divorce?
Yes.
I'll pass the witness, Sean.
All right, Mrs. Wilson, this is your opportunity to ask Mr. Wilson any questions you may have of the testimony he just provided.
I don't have any questions.
Okay, okay. All right, Attorney O'Barry, you may call your next witness.
No further witness from me, Your Honor.
All right, you rest?
I rest.
Okay. Mrs. Wilson, now is your opportunity to call witnesses. You may call yourself as a witness. And you're free to let me know whatever it is that you want me to know and what you're wishing that I would do here today.
Yeah, thank you, Your Honor. I'm calling myself as a witness. I'm calling in, in regards to the exhibits that I submitted. The first one being, I'm sorry, I'm gonna get up. I estimate from a collision repair shop to damages that were done to my car by Mr. Wilson. That is exhibit 1A and 1B. Exhibit 2 and exhibit 2A are also estimates in regards to those repairs. Estimates of repairs from the actual auto, the car lot where I got my vehicle, and I would like those submitted to the court. And then exhibit 3 is the police report, and it explains that on, I'm sorry, I have to pull it up. It explains that on 4/27 of 2025, I went to the defendant's house to take possession of the truck as it's solely in my name. I went to go take possession of the truck, and Mr. Wilson, in that process, sped up to his residence, and in his other vehicle, got out, hit my vehicle, got into the truck, and started to pull off. And as I was turning my car around to pursue him as he was trying to drive off, he ran over the front hood of my car, creating a lot of auto body damage to my car that had no damage on it. It was a new car at the time. And I'm asking for him to have to be responsible for repairing that back to its original state, which is those 2 exhibits of the collision repair. And in our pre-trial, our TRO, during that time when he was given like authority, I guess, over the vehicle, over the truck. He stated that like I didn't pay it off and he had given me the money, but he had abandoned the household and left me with all the bills for the house. So the money that he gave me to pay the truck off, I actually had to use to pay bills because I was actually on medical leave. At that time, I had emergency surgery January 28th. And was off from work for quite a bit of time. So I had to pay bills with that money. And I also had to pay the move out costs and repairs to the home that we lived in. So it wasn't like I had full notice that he was leaving. He just left me in the house. I actually found out that he was officially fully moving out the day that I had surgery while I was in the hospital. So because of that, I wasn't prepared to be paying all of the rent and things at the house that we had resided in together. So I did use the money that he sent over to pay off the truck. I used it to help pay for the bills at the house that we lived in. And then I admit also on my end that I did lead him on to believe that I had paid off the truck because in exhibit, there's a text message. In exhibit 5, it shows where he had previously like told me that he would cancel my insurance. Because I'm on his insurance, that he would kick me off of his insurance. And at the time I didn't know that he couldn't legally kick me off. So I was in fear of that. So I continued the lie of that I paid the truck off just so that he wouldn't cancel my insurance at the time because I was going through treatments for my illness. And then also, since he has been awarded the truck, since the time that he has had the truck, he's collected toll charges here in Texas, in Dallas and in Houston, and I submitted those. And I would ask that he be responsible for those charges, which is exhibits 4 and 6.
Okay. All right. Do you pass yourself as a witness?
Yes, I pass myself as a witness.
All right. Attorney Obera, you have any questions?
I do, Your Honor.
Go ahead.
Ms. Wilson, you referenced the police report, correct?
Yes.
Your Honor, I bring reference, and I believe it's to my exhibit 10, which is the police report. In this police report, this indicates as well that he attempted to pull out of the parking space and you attempted to block the truck with your Hyundai, correct?
That's what it states in the police report, but that's incorrect.
Okay. It also states in this police report that there was damages caused to his truck and there was also damages caused to your truck. Is that correct?
Well, the truck is technically mine.
No,
so,
I'm asking what's in the police report.
You mean damages to my car?
Based on the incident report submitted by Urban Police Department, doesn't it state that you attempted to block his truck while he was leaving?
Yes, that's incorrect.
And it also states that there was damage caused to the front of his truck, and there was also damage to your car, correct?
Yes, that's
so there is
yes.
mutual damages to both vehicles.
No.
Okay. So basically, if you didn't pull in front of his truck, there would be no damage to either vehicle. Wouldn't that be correct? Wouldn't that be a proper assumption?
Incorrect.
Okay. As well as you also made reference to lying to him about the paying of the vehicle. There has been an excess of over $20,000 paid to you for this truck. Is that correct?
Incorrect.
There wasn't a deposit of $12,000 sent to you and another payment of $8,900 that was forwarded to you from Mr. Wilson?
Yes, but all of that payment from the last payment was not made to go towards the truck.
Yet you still let him know that the title is on the way to him, correct? For the truck being paid off.
Yes, I was in fear of him discontinuing my insurance.
All right. So he relied on that money sent to you to be reimbursement for his truck, correct?
I would think so.
When you say, and you led him to believe that the payments made to you was to pay off his truck. Would you agree?
Yes, I did, because I was in fear of him canceling my insurance.
Now, what was your living arrangement at your apartment at the time? How many adults was living in your apartment? I mean, the rental house, the house that y'all had. I'm sorry.
2 adults.
It was 2 adults. Was not your adult son and his girlfriend residing in the house with you?
They moved in when he moved out.
Was there a payment, or was there an arrangement where all 4 of you were splitting the expenses of that house?
No.
So there was not a 4-way arrangement for?
No, there was not.
And did any rental payments come directly from the account of Mr. Wilson?
Yes.
And because of that arrangement, weren't you reimbursing him because of the arrangement that was made between you and the other parties of that house?
No.
Your Honor, I would like to bring your attention to Petitioner's Exhibit 9.
Okay, you can share your screen.
Yeah. I think this is it. Can you see this? Exhibit 9? Headed Naval Federal Credit Union. Ms. Wilson?
Yes.
Okay. Okay.
You said Petitioner's Exhibit 9?
Yes, Your Honor.
Hold on. That's not coming up on my Petitioner's Exhibit 9. The Petitioner's Exhibit 9.
I'm sorry. Petitioner's Exhibit 6. I'm sorry, Your Honor.
Okay. No worries.
I flipped it. Okay, going through these exhibits. Let's start here. What is this transaction of $700 that you would have sent to Mr. Wilson?
What date is that?
That's dated November 1st, 2024, I believe.
November 1st, 2024?
Correct.
For $700?
Correct.
That would be when he asked to borrow $700 to help pay for the rent, because he had just came off of a cruise with his family, and he asked me, could he borrow $700 because he was short on the rent, and that was his responsibility initially in our household debt. He would pay rent, and I would pay everything else at the house.
But wasn't the rent coming directly out of his account?
Is that coming out, or is that me going in?
That's the 700 going in, but you earlier testified that the rent was going out of his account.
Then that would have been when he was paying me back. He had asked, there was a time that he asked, could he borrow $700? He went onto a cruise and overspent on the cruise and was short rent, $700.
Okay.
He had to pay me back.
Okay. So what about here on November 29th, where you sent him an additional $630?
Did I send him or did he send me?
Says that you sent him.
There was a lot of times that we would send money back and forth from each other. It was, he's a gambler. So there's going to be transactions where I send him money or he has to send me back money that we're owed.
And I can agree with that, but wouldn't that also be transactions regarding a rental agreement that you had between yourself?
No, that would be money from his gambling.
No further questions, Sean.
Okay. Ms. Wilson, is there anything further?
Can I call him?
As a witness, yes. If you're done with your testimony, you can call Mr. Wilson.
Okay, yes. Can I call Mr. Wilson?
Yes, ma'am. Go ahead. And remember, you have to ask him questions.
Okay.
And your questions, you may hear his attorney make an objection. When you hear that objection, just stop speaking. Allow me an opportunity to rule on the objection, and I'll let you know when you can either ask your next question or Mr. Wilson has to answer the question, okay?
All right.
Okay, go ahead.
All right, Mr. Wilson, at any time did you tell me that you were going to take me off of your insurance?
Once the divorce was finalized, yeah.
So, Mr. Wilson, there was no time before you found out that you could not remove me that you made, that you spoke with my mother in regards to trying to take me off of the insurance?
I always knew that I couldn't remove you because when I filed for the divorce, it comes with a pamphlet that tells me what I can and can't do. One of the things that I can't do is I can't remove you from any type of insurance policies. I can't close out any insurance policies. I can't remove you off of my insurance, medical, or anything like that. It's a list of things that I cannot do. Now, what I told your mom was when your mom was saying that, well, when you was telling your mom that once I filed for the divorce, that they was going to automatically remove you from my insurance, I said that I wouldn't let my job know that I filed for a divorce. Now, when they tell you that once they find out that we was divorced, then that's on you. I have nothing to do with that. I just told your son the same thing yesterday. Like even after this, it's not my responsibility to go to my job and tell them, hey, I'm divorced. Whenever they update their policies or whatever, however they do that, you would know more about that than I do. But whenever they update their policies, then that's when they'll find out that we're divorced. If they just renewed the policy at the beginning of the year, then you will be on my insurance for a whole nother year. I never had any intention of taking you off of my policy. So.
Mr. Wilson, when did you initially file for that divorce?
It was the first week of February, I believe.
All right. Also, Mr. Wilson, at any time, did you ever borrow money from me for your gambling?
No, ever. Not one time. I gave you money from my gambling, but I've never borrowed money from you from my gambling. Ever.
So, Mr. Wilson, there was never a time where you came off of a trip and we were in the car and you were expressing to me how you did not feel like you could come to me and ask me for money and that you were going to be short rent that month?
I've never been short on rent. I've never asked to borrow money from you.
No further question. Oh, I'm sorry. Can I take that? Mr. Wilson, the day that of the car incident in April, you said that in the police report it stated that I pulled in front of you. I pulled in front of you. Is it not true that that your driveway is very narrow, and in order to get to turn around in your driveway, I would have to pull in front and turn around?
It's true that the officers viewed the video camera from my apartment and the camera that I was recording on my phone, that you literally blocked me in. You was head to head with me in a 2-lane street that you could not be making a turnaround. You was blocking me in. They saw it in the police. They saw it on the camera. They took the handcuffs off of me because they was finna arrest me for aggravated assault with a deadly weapon because you told them that I rammed your car multiple times. They viewed the camera, and then they viewed the recording that I have, and they saw that you was lying, and they took the handcuffs off of me, and they gave you a criminal trespass, and no charges was filed.
Mr. Wilson, did you not ram my car purposely?
I was trying to leave. You tried to block me in, and I tried to leave. I don't know what your state of mind was. You showed up at my apartment trying to take a vehicle that was mine, that I purchased. I don't know what your state of mind was. I was trying to leave, and you tried to block me in, and your car got hit. I got out, had my neighbor move his car so I could go around, and that's how I was able to leave. The police, when they came, they was about to arrest me. They had handcuffs on me, guns drawn on me, handcuffed me, and told me that I was being arrested for aggravated assault with a deadly weapon. I showed them the camera on my phone. Then I showed them the camera from my camera that sits over my door showing the parking lot. They saw that you was lying, took the cuffs off, gave you a criminal trespass. You made a couple of threats saying that you was going to ruin my life, and now we're here.
All right. Mr. Wilson, did the vehicle that you pulled, that you drove to the scene in, since the truck was at the apartment, do you not own that vehicle?
I don't.
Did you, Mr. Wilson, did you not purchase that vehicle from your daughter's mother?
I did not. I told you that I did, but I did not. Did I legally purchase it? No, I don't have a title to that car. I don't even have that car in my possession anymore. That's back her car. That's her car.
Mr. Wilson, did you not show me where you bought that vehicle and also had me add that vehicle to our insurance policy at the time?
No, I added it to my insurance policy because I was driving the vehicle. You have to maintain financial responsibility on the vehicle. So I had to have insurance on the car because I was driving it. But it was in my policy. It was never into your policy.
No further questions.
Okay. Mrs. Wilson, do you have any other witnesses, or do you rest?
I rest.
Okay. Ms. Wilson, do you still have your vehicle?
Yes, I do.
What kind of car is that?
It is a 2024 Hyundai Elantra.
And Mr. Wilson, you have the 2015 GMC Sierra truck?
That's correct, ma'am.
All right. So after the court has heard testimony from both sides, the court is going to grant the divorce on the grounds of insupportability. The court is also going to adopt the associate judge's report of August 24th, 2025, where both parties are enjoined from causing any damage to either party's vehicles or belongings, whatever the case may be. Court is awarding Mr. Wilson his 2015 GMC Sierra truck. The court is also awarding Mrs. Wilson her 2024 Hyundai Elantra. Each party will be responsible for their own repairs of those vehicles. The court grants the judgment in favor of Mr. Wilson in the amount of $4,083.50 as previously ordered in the temporary orders. Has that been paid?
No, Your Honor.
All right. The court is also going to order that interest is added to the judgment. The statutory interest is 6%. Mrs. Wilson, I highly encourage you to pay that judgment because there will be interest attached to it. So every month that is not paid, that balance grows. And Mr. Wilson has the right to collect on that judgment in any way that the law allows him to do so. So I would highly encourage you to start paying those attorney's fees on that judgment. And that's pretty much it.
Your Honor, am I not going to be awarded the toll charges that he has ran up in my name?
I don't mind paying those. It's my responsibility. I pay that.
What? That's the $1,500.
There's one for 15, and then there's another one from Houston.
Okay, hold on. I forgot about those. 1 second. And Mr. Wilson, how did you get $1,500 in toll tax?
It's not $1,500. I can promise you that. I don't know where she getting that.
That is if you look at the date of that.
Hold on 1 second. Hold on 1 second. You all do not have to argue with each other. I have it right here in front of me. It says $1,508.48 due on February 5th. I'm not going to read the license plates out loud because we are streaming, but it starts with a V. Whose license plate is that?
That's mine.
Okay, so that's the amount that's due on February 5th of 2026. So I'm ordering you to pay that directly to the National Toll Tag Association. That amount is $1,508.48.
And then in exhibit, there's a Houston chart. There's Houston tolls.
Yes, that one is. Oh, now that one is small. Hold on, let me zoom in on that one. Oh, that one, it says no amount is due.
No, it's $131.03.
Okay, it says total payment amount $131.03, discount $24, total payment amount $107.03, remaining balance still due $0.
Yeah, they took the money from me. I had to pay it.
Okay, I understand what you're saying. You're asking for reimbursement.
Yes.
Okay, Mr. Wilson, I don't have a license plate number on this one, like the national. Yes,
it's
it
up
is.
in the
It's at the top. It's the same license plate that's on the national toll tag. So I'm going to order that you reimburse her hold on. What is this? So 107.03 is what you paid? No, you paid 131. It gave you a discount. So 107.03.
Yes.
Can I ask something real quick, Jana?
Yeah, go ahead.
So when I do this, I make sure that I do it correctly. So it's saying $1,500 for that truck in the last year. I've only had the truck for a year, a little over a year, but for almost 7 months dealing with this process, I haven't been driving it. So I don't know how they messed up, but when I pay it, I'll be paying it directly through them. So whatever they have me pay for that particular truck during the months that I've actually owned it, which was August of 2024 to now is what I'll be paying, right? Nothing for her car that's attached to it or nothing like that. It'll just be for that particular vehicle.
Yes, from what
Okay.
I can see, it's just that vehicle only.
Okay. Yeah, I don't mind. It's like I say, I'm the only one that has ever driven it. She's probably been in that truck one time, so she has no ties to that. So I can pay whatever is, tied to that truck. But I didn't want to be having to be responsible for paying for any of her toll fees or anything like that.
No, this
Okay.
is strictly that license plates. So
Okay.
the Houston Toll Tag Association, you
That
owe
was
them.
me.
I'm sorry,
Yeah.
not Houston. You owe her directly 10703.
Okay. So how do I pay that? Making sure that I get confirmation of that. How do I do that?
Payment to her. So, ma'am, which forms of payment do you have? Which forms of payment have you all used in the past? Zelle, Cash Out, what have you done?
Zelle, Cash App, Apple Pay.
Okay, whichever payment method that you decide to do, it needs to be specifically put in the order because I don't want there to be any confusion. So you all said Apple Pay, Cash Out.
I can Apple Pay it. I can Apple Pay it right now if I need to.
Okay, yeah, go ahead, do it right now. That'll take care of that. So then that way we'll still put it in the order to show that it was ordered, but that, you've satisfied that so you don't have to worry about it any further.
Judge Bailey, when I'm paying back the fees that
I just said one already.
being awarded,
Actually, I thought we blocked him.
You blocked.
yeah,
I just
my
tried to
phone.
spend Apple Pay. So
So did the money come through although he's blocked?
Let me see. Yes.
Okay, so the 107 has been satisfied. So what you have left, sir, is strictly to the National Toll Tag Association, okay?
okay.
All right. And
Yes.
then Mrs. Wilson.
Do I pay him directly or do I go pay through the attorney?
You paid the attorney. So when it comes to attorneys, I would recommend you do either a cashier's check or a money order.
Okay.
And you would pay that directly to his attorney's law office address. Do you have that?
No.
Okay, Mr. O'Bara, you need to get her that information to make sure that you get paid.
I will send her that right after this hearing.
Okay, and then I'm also going to order you to draft the order. How long do you need to complete it?
I have 30 days.
You can have, let me see.
15. Can I get 10 days? 10 days, John.
Okay, I was gonna say, you won't get 30 days in here.
Your Honor,
February 6th, yes, ma'am.
before everything is finalized, can I ask that I get 90 days to transition out of his insurance?
Yeah, I think that's fair.
Give it a whole year. I don't care. Like whenever I don't plan on telling them that we divorce. So whenever they catch on that we divorce is when they would take her off. I don't know how they do it. I don't know if they renew it every year or what, but if they renew it every year, she got a whole nother year. So
You're talking about health insurance, right?
correct.
Correct.
I literally just told her son yesterday, like whenever they change it is when they change it. I'm not worried about letting them know what they supposed to be doing.
Okay. Okay, so I just write it like that. 90 days to get your own health insurance. And how long do you need for, because this Well, the balance is already past due on the attorney's fees. So I don't have to give you another date on that. It's the judgment. You just need to make payment arrangements with her attorney as soon as possible.
Okay, so I'm kind of confused on that because it's not this attorney, it's another attorney.
It's the same firm.
Oh, it's the same firm. Okay.
Yes, ma'am. So just, and thank you for saying that. So you can make it payable. It actually is payable to the firm, right?
Yes.
Okay. So you'll make it payable to that firm with that firm's address.
Okay.
All right. And of course, if you can't pay it in full, just pay something. You need to make sure that you're actively paying on it because like I said, it is a judgment and it's going to accrue interest every single month. And I have you all on the dismissal date for February the 6th. If you are able to get the order back to me before then, great. That date will, send the order to my coordinator. I'll sign it and we'll remove that date off the docket. If not, you have to show up on that date and you're allowed one reset after that.
Yes, sure.
So,
all right. And that'll be with Judge Lee on her Zoom code. And I'm going to, I can put the Zoom code in the chat for you, actually. And Ms. Wilson, did you have a question for me?
So February 6th is like the final?
Well, today is the final. So today I've actually rendered you all divorced. So you're divorced as of today. February 6th is the date that I give you to get the order entered. That, the ruling I just made today. So to finalize that specific ruling that I made, I'll sign off on it. So you have until that date to get the order. So the way it'll work is Attorney O'Bara will get you a draft of what my ruling is. You will review it. If everything looks good to you, you can sign off on it. You can choose not to sign off on it because the only person's signature that matters is mine, right? So you can, like I said, you can sign off, you don't have to, and then he will have to set it for entry if you object, which you would appear on February the 6th and, state whatever your objections are. However, just because you object doesn't mean I'm going to not sign the order. Does that make sense?
Yes.
Okay. All right. Is there anything further for the record?
So question. So
yes, sir.
I know you said that you are signing with the previous temporary orders. So with the vehicle and all of that, how does that work as far as with transfer of the title, or do I got to wait for her to pay it off in full, or do I got to wait the full term of how does that work?
That's actually a great question. So it is a form available on the Texas DPS website that you all can go ahead and do the title. And Attorney O'Bara, he can help you with that.
Well, because she haven't finished paying it off yet. That's why I was questioning, how does that work?
You can still change title, but the lien will be there.
Correct.
So it'll be a title subject to the lien. So yeah, I can walk you through that process.
Okay.
So Your Honor, can I add to the order, just an order ordering both parties to sign whatever proper documents to make sure title is transferred?
Yes, please. And make sure you put a deadline in there.
Okay.
I would say no more than 2 weeks as the date, but actually put a date. So whether that's February, what's coming up? Whatever that following date is in February 3rd, February 4th, something like that. Put the actual date and time for them to have it completed. That way it's enforceable.
And Your Honor, let me ask it. Can I input that the balance as a money judgment as well? And the reason I'm asking, in the event that the vehicle may have to be No. I'm talking about for the vehicle. I'm talking about the vehicle. Just for example, if he has to trade in the vehicle, if he has to do anything, that balance, the lien is still going to have an effect on him in terms of, trying to convey the vehicle from his name to anything else. And if she hasn't paid it off by the time he's wanting to do that, it's still going to leave him in a situation where he's still responsible for that amount.
Sure. Yeah, because when you do the order, you have to put the VIN number and everything like that associated with the car.
Okay.
So you have to put because there is the lien holder information, the balance as of date. I think all of that is relevant in a situation like this because there is still a balance.
Yes, sure.
So in the event anything like that happens, if the lien holder has to, what do you call that? What's that word? You know where I'm talking about.
Yeah. Well, I ain't sometimes thinking not foreclosed, but repo.
It's not foreclosed, but you understand what I'm saying.
Yeah,
When they
yeah.
have to, when they have to move forward, repossession. Thank you. They can at least see the order to see, what the balance was and who was awarded the vehicle and everything like that. But that's the reason why that title that paperwork needs to be done within a very quick turnaround time so you all don't run into that issue.
Yes, sure.
So do I need to tell them the amount that's left on it?
Yes.
Oh, $4,243.92.
This will be easier too. That amount, we have it in the record, but send his attorney a copy of the last statement, whatever you just read from, send his attorney a copy of that.
Okay.
Okay. All right. Well, thank you all.
Thank you, Your Honor.
Thank you, Your Honor.
The 5 you like.
Well, that's going to be, excuse me, that's going to be it for today, ladies and gentlemen. I'm going to go ahead and call it for today. Tomorrow is, let me see what's on the schedule. This thing changes so much. Judge O'Donnell. So please tune in tomorrow for Judge O'Donnell. And in the meantime, ladies and gentlemen, please have a wonderful evening. Ta-ta and ciao-ciao. I will see you on the next live stream. Bye-bye now.
Breakdown, you're the one I call. From the mountains high, come down to it all. With your tools in hand, making magic flow. Every broken part, you help me grow. You fix it all, fix it all. You fix it all. Daniel, you make it right. Daniel, everything's right. When I'm falling apart, you put me back together. Daniel, you make it better. From the wires tangled up to the broken dreams, you know how to man all my scattered seams. With your steady hands, you refill my heart. Every piece that's lost gets a brand new start. You fix it all, fix it all. You fix it all. Daniel, you make it right. Daniel, everything's bright. When I'm falling apart, you put me back together. Daniel, you make it better. Fix it, Daniel. Fix it, Daniel. Make it right when the world shuts down, and I can't see clear. You're my solid ground, always drawing near. Never give up on this heart of mine. Put it back together every single time. Fix it all, fix it all. Everything's